Hello, and a very warm welcome to all our viewers who've joined us today for day two of the Global Law Schools Summit 2021. It might be a very good morning in India, and it could well be a late evening in North America, just about afternoon in Australia and New Zealand, and probably a bit more early in Europe. We have today with us four highly distinguished panelists for this session 8 of the summit, that is transforming the text, changing themes in legal publications. In no particular order, I would like to introduce the panelists for this session. We have with us this morning Professor Dr. G.S. Bajpai, the Vice Chancellor of Rajiv Gandhi National University of Law, Patiala, Punjab, India. Professor Dr. Donna Nagy, Acting Executive Associate Dean, Indiana University, USA. Professor Maria Isabel Aninat Sahli, the Dean of Law School, Universidad, Adolfo, Ibàñez, from Chile. And we'll soon have with us Professor Charles Maimula, the Deputy Dean, Faculty of Law, University of Pretoria, South Africa. The theme of this session is quite inherent in what we as legal persons or legal scholars carry out in our day-to-day lives, more specifically in academia, research and writing. Early days of globalization witnessed a big epistemological movement in the pages of law journals, as well as law reviews and monographs. There was an unprecedented turn to legal studies, as scholarly anxieties on the nascent world order occupied the pages of law publications. Most of those writings pertain to the fall of modernity, loss of professional and disciplinary exclusivity, new subjects, critique of orthodoxy, autocritiques, self-reflections on professional convictions and sensibilities, and new movements and approaches. International, comparative, and transnational law became the predominant themes of reflection. Methods, styles, language, materials, and intellectual traditions were either celebrated or critiqued. The predominant mood was gloom and melancholy. The postmodern anxieties, as article or book titles, bore expressions like death, fall, decay, doom, limits, apology, despair, nihilism, and ambivalence. However, with the passage of time, 2 decades into the new millennium, a new hope began to rise as alternatives became the central theme of discourses. There permeates among voices of discontent a hope of being in the opportune moment to rebuild the world if not to adopt and be resilient. Yet at the same time, one cannot completely ignore the inherent reluctance on the part of a section of scholars to switch to these alternatives. Now, whether it is down to philosophical allegiance or a plain rejection of the change in the status quo of legal scholarship. Furthermore, research and writing with alternatives as their central theme are to a large extent dependent on academic freedom afforded to scholars and researchers by academic institutions, meaning thereby that the role of higher education institutions becomes extremely crucial and important. And it is against this backdrop that we are going to throw some light on how legal research has changed, more predominantly, how the text has changed in the writings over a period of time over the last at least 2 to 3 decades. So without further ado, I would like to ask my distinguished panelists the first question. And that is, this language of alternatives has been quite prevalent in legal publications in early 90s. To the extent that there were even journals and books named or carrying the tag alternatives in their titles. It also appeared that there was a renewed courage and confidence on the part of the authors to speak about alternatives. Interestingly so, this was ubiquitous across all branches of law. It raises a question. Does this indicate that there was a collective discontent with the past or present epistemologies? And if that is the case, how would our panelists today perceive the rise of discourses on alternatives in their respective areas of interest? Is there any pattern to be observed in such discourses? Where have we come to? Where have we reached today? Where have these alternatives taken us to? So I would like to ask the panel as to their thoughts on this particular aspect of alternatives in legal publications. Dr. Donna, would you like to go first?
Well, thank you so much, Manveen, for that very insightful introduction. It really sort of sets the stage nicely for a discussion that I've been much looking forward to, and it truly is an honor to join you all. It is my evening here, 9 p.m. East Coast time, and so, but I'm looking forward to a lively discussion. So, alternatives, you know, it dawned on me that it might be useful to preface this discussion by talking a little bit about legal publications and the audiences that we write for, and because when we talk about publishing alternatives, it across the field, it is appealing to a group of different audiences. And so In the United States, among US law schools, the initial decision makers on law reviews and law journals are actually law students. And so now that is in general, we have a number of, in every field, there's a number of very prestigious peer edited law reviews and peer edited journals. But predominantly, journals in the United States are edited by second and third year law students, and the articles that are chosen by second and third year law students. And so I preface the response to your question with that background, because when we talk about things like disenchantment or pushing back on conventions, initially for the law professor seeking to publish in a student edited journal, one has to recognize that the audience is someone with very limited breadth and very limited understanding of the law. So part of the challenge before one presents an alternative perspective is very carefully outlining the initial perspective that one is pushing back at. And that probably would not be the case in a peer edited type of format there. I think that really does change the landscape somewhat. In my field, so I teach and write in the area of corporate law and even more particularly securities law. And so in the 1990s, as we sort of start, I'll take securities law. There were questions about the source of regulation. Extraterritoriality was a very significant topic, and the question of how should companies be regulated in terms of their securities disclosure? Should it be where the companies are based? Should it be where the securities are listed? Should it be where conduct occurs? And so much of the reaction in the legal discourse was framed around this alternative concept. But I'll stop because I'm kind of interested in hearing from our other panelists in terms of their approach.
Thank you, Dr. Donna. Dr. Bajpai, would you like to throw some light on how do you perceive this aspect of alternatives specifically in the subcontinent and also let's say the Indian context, considering that we don't really have all the journals as student edited law reviews or student edited journals. We also have peer reviewed journals, and some of them are edited by some highly distinguished scholars and stalwarts in the field of law. So what are your thoughts on this particular aspect?
Oh, thank you, Dr. Manveen. Actually, my idea of alternative lies in the fact that I consider it to be a very unique mode of legal inquiry. First of all, let us understand the nature of alternatives as a mode of inquiry within the framework of legal research and largely within the framework of legal education. So when I say alternative is an evolving process in any particular discipline, because if you see that there are different kinds of modes of inquiry and research in a particular discipline, more specifically to the field of law, if we can see that there has been a dominance of classical scholarship, which was more and more concentrating on those conventional paradigms And I'm using the term paradigms to denote the state of inquiry, as we understand that these paradigms are the concrete, they are the theories or concepts which are concrete application to theory and to the understanding of the subject matter of a particular. The issue is whether this transition of classical scholarship to alternative scholarship means something which is very unique to the field of law, or is it an evolving process within the framework of a discipline? That is first. Because this drift, what we call paradigm shift, why the paradigm is shifting to alternative scholarship? There are two very interesting reasons. One is that you yourself posed this question, whether was there any collective discontent amongst these scholars or amongst the scholarship community to utilize certain other ways to explore the truth, objectivity, and all that. So probably that process happened in all the places, including India, when we have started looking at what I call from rhetoric of law to the reality of the law. So reality of the law gave birth to the realists. Still, they were sort of looking at the context in which the law is enforced. However, the alternative scholars have come out with a very unique mode of inquiry. They were trying to look at why of the law rather than what of the law. So why of the scholarship has taken them to that kind of paradigm shift where the evolving of critical legal studies took place. In fact, the critical legal study tradition in the field of law is one of the consequences of the resorting to alternative scholarship in all places. So even in India, for instance, the growth of feminist studies, gender studies, environmental law studies, critical criminal law, like you asked about India. So during my days at National Law University, Delhi, when I was teaching criminal law, I started posing alternative questions within the conventional framework of criminal law. So conventional framework of criminal law is essentially black letter law. It is more of the rhetoric of the law. But if you take to the questions, if you go to the questions of the critical reflections on why of the law, then probably we look, because this critical scholarship has given birth to social activism. That is very important. And that is why the alternative scholarship is growing. Because generally there is a community of scholarship who are essentially are the believers of a status quo in the scholarship. They do not want to change the system, institution, and the scholarship tradition as such. Alternative scholarship is posing a challenge to the nature of scholarship, looking beyond the conventional domains or classical domains of understanding of a phenomena. That is why in India, this alternative or critical scholarship has impacted the course of understanding of legal issues. So if you see, it has impacted the courts, and courts are now giving decision. You are aware that we have LGBT decision, we have privacy decision. This is a paradigm shift. And this shift cannot take place unless you start believing into the alternatives paradigm. And alternative paradigms are actually, as I am saying, I'm very happy that you have chosen a topic. I haven't seen in the recent past this issue being posted as one of the subjects of discussion. And I'm saying that it has impacted the course of scholarship in India drastically. Therefore, we are finding now publication prefixing critical or prefixing alternative, because alternative thinking is a reality. And I would go on to the extent of saying that it is not the growth of a subject, it is the growth of a scholarship. It is the indicative of the growth of a scholarship. So we now juristic thinking is shaping the course of alternative scholarship in India. Therefore, we are finding a lot of issues are becoming very, very important. I know there are obstructions in the growth of a scholarship. Probably we can discuss that issue a little later. But yes, there is a growth. But I would say this is not a collective discontentment in the sense that there is any kind of coercion involved. Rather, it is a natural growth of a discipline. And I can foresee we have installed a very new subject, probably that prefixing is not happening many places. So we introduced a subject in postgraduate studies in criminal law, critical criminal law. Now, critical criminal law means we are looking at the alternative traditions within the framework of that subject. And there is a community of critical thinkers in all fields, including criminal law, who are giving alternative paradigms. So there is a paradigm shift, like I teach mostly victimology in law school. So victimology, in a sense, is a paradigm shift from offender-centric thinking to victim-centric thinking. And when you fix your lenses from offender to victim, it means you are changing the nature of discourse in a particular discipline. Lastly, I always feel some of the subjects, specifically like criminal law, we have treated this subject as if the entire ownership of this subject lies with the state. So transforming from state criminal law to public criminal law, people's law, that transition is also very important. And all this, in a sense, indicate the evolving of alternative scholarship. And alternative scholarship, to me, is a genesis of the critical traditions in the field of a particular branch of law. And as I have just mentioned, the net result of this transition was social activism. Social activism came but for alternative scholarship, because they were the activists. They were actually posing critical question to the establishment, to the state, that you need to do this way. There are LGBT community, there are gender issues, there are environment issues, there are other kinds of issues. So state needs to give attention. Though they become marginalized within their own sense. And I also feel, I'll comment on this, that there is a lot of othering has happened. This otherness has happened. So generally, we treat alternative scholarship as othering, as otherness, which is not a correct fact. Probably we can reflect on this particular issue a little later. Thank you.
Thank you so much, Dr. Bajpai. I would say there possibly, and this is my personal opinion completely, there cannot be a better conversation on the aspect of alternatives than by touching on the LGBT community and their rights in today's date. I think across the world, the amount of discussion that has been going on and the way people have come out in support of the LGBT community is something wonderful. Just to kind of drive home the point that alternatives are actually starting to find a place, not just in the books and writings, but out there in reality. And I'll come to that, Dr. Bajpai. Again, you've given me quite a few points to actually, take this discussion forward. For now, I would like to go to Professor Isabel. Professor Isabel, I was just wondering, Dr. Bajpai touched on the aspect of how things have been in the Indian context, and let's say with respect to LGBTQ community, and how we've seen that change. I was just wondering, how have things been back in your part of the world with respect to this dialogue on alternatives and their place in legal scholarship? So your quick thoughts on that.
Thank you. Thank you for the invitation, for having me here. It's almost midnight in Chile. So this is the wonders of Zoom, actually. So I'm going to speak on what you just pointed out on your remarks, but first, a little bit of context about Latin America. I would say that the professional legal academia in Latin America sort of has uniformed the forms of production a bit later on than what happened in the US and in Europe. So we're a little bit behind in terms of standard forms of production of legal research. Our journals are mainly peer-reviewed in contrast to what happens in the US, right? But we have also seen these new topics emerge with very much force, I would say, part by different reasons. I would say one specifically would also be the fall of dictatorships that were present in the 70s and in the 80s in various countries in Latin America, including Chile, of course. And if you check, for example, in the Chilean law journals, the keywords that have the most published papers are actually on human rights and human rights discourses. That englobes LGBTQ, gender issues as well. And I would say that also it's very interesting to watch the transfer from the legal academia to what is happening in reality, to what your remarks just actually went to. I would put this in context. In the Chilean example, we're undergoing a constitutional change. We have a constitutional convention here in Chile. It started sessioning at the beginning of July, and it will go on until at the first months of next year, actually. It's a year in total. And you see that the defining issues that are being discussed, we're discussing a whole constitutional change, right? So we're discussing the political system, we're discussing social rights, but then some of the key issues are gender rights. Another one I would say it's human rights in general, of course, again, related to human rights violations that occurred a couple of decades ago, but one that is very Latin American that has also come from, in part from the legal academia, not exclusively, is indigenous peoples. So the concept of plurinationality and what does that mean and define the concept of a nation state. So these are some topics that are very, as you just mentioned, being discussed abroad, but also some are very, have been very relevant for the legal discussion in Latin America, particularly indigenous peoples. And the indigenous peoples today in Chile have a defining issue within this constitutional context. So the question is, of course, who the audiences are in terms of the academia, but also how does that audiences also relate to the general discussions that are happening in the country. And what I would say, what areas of the law have been more prone to these issues of, or the alternatives, as you mentioned, I would say that are much more related to these type of issues and to constitutional law or public law than to other private discussion or private law discussions, as Donna mentioned. And we can talk about it later, but what is the role of comparative constitutional law? And I would say that has been also very important in the Latin American context as well.
Thank you, Professor Isabel. That's quite insightful, and that actually brings me to the next point. Sorry. Each of our panelists today touched on some aspects of public law, private law, and comparative law. That actually brings me to the next question, and I'll throw it open to all of you again. When we talk about comparative legal study or comparative law, it's basically nothing but a theoretical study of legal systems in close comparison with each other. And it has, of course, gained importance over the years. So much so that of late, there has been a rise in the number of writings on comparative law. And all of you present today here are scholars who've written on comparative law. So the question that arises then is, and what I would want to know from you, and I'm sure the audience would also want to hear from you, is the quality of published comparative law literature right up there? Or do you think there needs to be a change? There needs to be an improvement. There needs to be, like Dr. Bajpai mentioned that phrase in the beginning, paradigm shift. Is it required? Or do we say, the present quality of literature in comparative law is good enough, and we can actually live with it. More so, is there an inclination towards comparative studies being carried out on just public law? Or is there adequate focus by journals and law reviews in the area of comparative private law? What are your thoughts on the same? You may go one by one, and I'll of course come to you. So who would want to go ahead with the response to this particular question?
Maybe so I'll start just sort of stepping back and thinking about even this incredible conference that you've put on and will be putting on for the 3 days. I think that the pandemic has taught us worldwide a lot. One of the things, though, is the ease of collaboration. Through the wonders of Zoom, we now recognize that we can communicate, at least for me, in a whole new way in terms of thinking of projects. And so one of the expectations that I have as we emerge from this is that the relationships that we've built virtually, we will be able to build upon. And I think that will be reflected in scholarship through comparative projects. And so I think some of the best comparative scholarship in the areas of corporate and commercial law and securities law are collaborative enterprises where professors from different jurisdictions work together and do a mutual comparison of the regimes that they are most interested in, and truly drawing lessons, truly drawing best practice in the area of business law in particular, because business is so multinational. It's imperative that when we think of issues, we think of the worldwide impact and not just the jurisdiction in which we're writing. So the trend that I would see in the quality of published comparative legal literature is going to be increased collaboration and increased learning in the vehicle of whether it's a book or a collection of essays or law journal articles.
Right. Thank you, Dr. Donna. Professor Isabel, would you like to go?
Sure. I would, different things, right? I would say that comparative constitutional law has produced, especially in the last few years, very interesting new production in terms of methodology. I would say that before we used to see a lot of, I would call it, because I don't find the appropriate term, but a sort of a cherry picking of certain regulations in terms of trying to put together an interesting production. And what we see today is that the methodology of approaching comparative constitutional law has produced very interesting articles and also not only academic research, but also databases. I'm, for example, thinking in terms of Tom Ginsburg, a US professor who has this constitutional website that allows you to research constitution and their amendments, and also a sort of network, actually. I don't know if you know ICON, the International Constitutional Law Society, that has national chapters. There's a chapter in Chile, in Argentina, and that has produced virtual or even actually local opportunities to meet and to sort of advance on different topics. And I would say also that within Latin America, comparative constitutional law, as I mentioned before, has a big importance. I mean, in terms of what I referred before as the example, but the constitutional change in Chile, we look very much at the process that Colombia had in the early 90s, that Venezuela had in the late 90s, that Brazil had a bit before, right? So even within the region, there's a lot of conversation of what went on a specific topic. I would say that in terms of private law, this is a bit behind. Maybe there's a very interesting discussion on the principles of contract within Latin America, but I would say it's still in an initial phase compared to what I mentioned before in terms of comparative constitutional law. And I would say that a different area that sort of pushes for benchmarking is antitrust. Because of OECD regulation, because of the US system and the European system, I would say that antitrust and general market regulation or regulation of the economy has promoted a very compared sort of benchmarking, constant benchmarking of where regulation should move and what are the issues, and that has produced a new area, at least in Latin America, that has been very, very important and will be, I would think, for the next few decades as well.
Right, right. Thank you, Professor Isabel, for your thoughts. I would now like to ask Professor Bajpai, considering that you are someone who's known for having written extensively on comparative criminal law and comparative constitutional law, and yet, you know, there are several other facets stemming from these two aspects of law. What do you think is the right approach towards comparative legal writing? Dr. Bajpai.
Yes, it's a very fascinating question, because the comparative law scholarship is a traditional thing within the legal studies in India, especially in the field of public law and more specifically in the field of comparative constitutional law. However, so far the comparative law scholarship has been rooted within the comparables. So India being the common law country following adversarial process, we have been, you know, benefiting from comparative scholarship initiatives in different common law countries, more particular in the UK and Australia and many other countries. And in fact, the course of comparative law scholarship was hugely impacted within the field of constitutional law, criminal law, and other, you know, public law fields. And therefore, I can visualize that the impact is now visible more and more in terms of adapting the best practices which are happening in other countries, rather than substantive law, practical aspects of the law. So like, for instance, the issues relating to criminal law, liability principles, gender issues, equality issues, freedom issues, policing issues, we have been benefiting a lot from, for instance, the experiences that we have in the UK. And now the scholars in India have better ties with overseas scholars in terms of carrying out joint projects. And I, at one point of time, also see the impact on non-comparables, like non-comparable jurisdiction. Say, for instance, during my tenure of a teaching in one of the places in Germany, Germany follows essentially a civil system. So they were quite enthusiastic about knowing the methods of teaching and scholarship that we follow in common law system, in adversarial system, mainly using case laws more and more. Whereas in in civil law system, they are more and more on law itself. So they were trying to infer and trying to understand whether the case law method could be a very interesting way of promoting legal scholarship in those countries which are essentially following the civil law system. This is very important. And I can tell you with a lot of conviction that the scholars in Germany particularly, they are more and more trying to adapt some interesting features of common law system. And therefore in India also, if you remember the Malimath committee, which was appointed for the reforms in criminal justice, it has suggested to adopt certain aspects of inquisitorial system, which is prevalent in Europe, in order to provide a right-based centricity to the victims of crime when they face trial and all that. Because in inquisitorial kind of model, judge has a very important role to play and to intervene. So what I'm saying, the comparative law scholarship has now led to the adoption of best practices in different countries. So not essentially we are following their system, but we have recently adopted lots of things which are very unique and important in those countries, though they are following a different system. So comparative law scholarship is now looking at, like for instance, in the field of constitution law. So when Nepal's constitution was in the making, Nepal's constitution has essentially captured a lot of things which, mainstream countries do not have. Like for instance, the Nepal constitution now has right to health as a very explicit fundamental right. India or for other countries, do we have right to life, within which we claim that the right to health lies. So I'm saying the countries which are now redefining their constitution, are bringing amendments in their constitution, are essentially capturing those things which are now forming the part of central debates. So that is the advantage. And second thing which I find, which is a byproduct of comparative law scholarship in many countries, is the reform process. I would say criminal law reform process, or law reform process as such, is getting hugely impacted by developments in comparative jurisdiction. Two countries I can very easily mention here. Very recently, Sri Lanka has done a lot of reforms in their criminal law. And they were looking at India, they were looking at UK, they were looking at Australia and US also, in order to capture those best practices which can be factored into their law reform process. I am on the board at the moment for Criminal Law Reform Committee. I am the part of Criminal Law Reform Committee in India. And in my practice, or in my engagement of criminal law reform at the moment in India, I'm essentially capturing the broader principles which now inform the due process consideration, our progressive aspects, our humane criminal justice aspects in different countries. So we are essentially learning from the core and central debates which are dominating in different countries to ensure the reform process in my home country. That is very, so probably the comparative law scholarship has not taken up to the extent of considering the reforms in the criminal or in the legal process. That is very important. And third is the theoretical contribution of comparative scholarship. Now, theoretical evolving of theoretical concepts or theoretical contribution has been a very, very dominant and very important, current. Now, people in alternative scholarship are doing huge work. Like in 2021, just a book has published. Other day, I was reading Jamal Green. He has written the wrongs of right in the United States of America, how the rights discourse is impacting negatively the United States of America. This is alternative scholarship. Or for that matter, in the US, when former dean of Harvard wrote, "When should law forgive?" A very, very alternative discourse. A law which is growing very, very punitive and retributive in many jurisdictions. Martha is writing, "When should law forgive?" So these are the, and now back in India, In other countries, we are looking at forgiveness as one of the options in our adjudication of the cases. So I'm saying theoretical contribution of comparative law is very, very important. So practice side, theoretical side, and reform side. Three very important sides are there where comparative law scholarship has benefited the countries drastically. Thank you.
Thank you so much, Dr. Bajpai. I think it's fair to say that when we talk about comparative law, we of course cannot ignore the aspect of case laws. Inevitably, we end up, comparing case laws across jurisdictions. There might be similarities, there might be dissimilarities, and there might be more specifically similarities in the application of law. If there is commonality between two legal systems, then we do end up comparing different jurisdictions, different decisions in those jurisdictions, and how their implementation over the years has impacted the evolution of law across jurisdictions. Which brings me to the next question, and that is that the traditional practice of reporting case laws in journals is of course time tested, and it draws cross-jurisdictional parallels and allows for the adoption of a holistic approach to judicial analysis. At the same time, the changing ethos of society can result in some adaptations and deviations in the subsequent judgments without disturbing the sanctity of law as is laid down. It therefore raises a pertinent question, and that is experimentation advisable instead of mere flexibility in precedent laws, which would then keep the social fabric intact while undergoing constant evolution? So is it so that if we are to choose between flexibility and experimentation, you'd probably go with experimentation and not complete flexibility because we're not really sure what's going to happen? So I would want to ask Professor Isabel, what exactly is it in Latin America that would probably help you to answer this particular question? Professor Isabel, over to you.
Thank you. Well, this is a difficult question for Latin America because we come from a civil system and then we move away right from the precedent law. And I would say that we navigate in a system of tension, right, between sort of certainty and then justice in the particular case. I'm going to use the same example that I've been using the whole panel, but we are now in the midst of a discussion, as I mentioned, of a change of the whole constitution, and that entails a discussion of the justice system. And if you see if you watch the convention in Chile, and you can actually watch it because there's a TV channel, part of the discussion is, well, what should the role of the Supreme Court be in Chile? Should we move to a similar system, much more like the US? Or should we maintain what the Supreme Court in Chile does? And that is, I would say, an option for justice in the particular case, moving away from the certainty of the present system. And I would say that because of this context, the role of the academia in analyzing case law has been much more focused not on the rupture and not on sort of moving things ahead, but much more on sort of analyzing the development of jurisprudence and of what are the trends, and sort of also identifying what are the legal vacuums that we have to address, right? So our framework actually is very different from yours. And I would say that that goes right to what we were discussing a little bit before. What are the challenges of having these different points of origin or frameworks for doing comparative constitutional law, actually. In some areas, I think the discussion is different, but in this particular area, I think the initial point is very, very different. I don't know, it's better or worse, but it's just different.
Okay. I think that's a valid point, because we cannot really say that, you know, countries or jurisdictions across the world would probably have the same outcome when we touch upon this particular aspect of law and presidential law as such. On that note, I would like to ask Dr. Donna as to what exactly is it in America that prompts you to probably side with one or the other aspect of alternatives.
Yeah, you know, as Professor Isabel was talking about the role of our U.S. Supreme Court, and we're thinking of sort of stability versus experimentation, I'm sort of struck by the irony that today our United States Supreme Court for 2 hours heard arguments in terms of whether the longstanding reproductive freedom decisions of Roe versus Wade and Casey versus Planned Parenthood, the right of reproductive choice, is going to stay as the law of the land here in the United States or not. And so this whole discussion is such a timely and sort of heartfelt issue in contemporary. The Trump presidency as well, and the sort of post-President Trump Supreme Court. I'm not sure where the stability is going to be. I mean, it is a constant topic of conversation in terms of the political nature of judging, and we may very well be seeing many of our cherished precedents being just, you know, one after another coming down. So I did want to respond to that aspect of Professor Isabel's point. Dr. Manveen, though, you had a particular issue you wanted me to focus on.
Yeah, so what I was actually pointing at is the fact that, you know, whether we could say that flexibility is something that could be adopted as a norm or as a more preferred option over the experimentation. You know, when we talk about reporting case laws in journals or largely speaking, how we approach legal writing. You know, so my point was specifically, simply speaking, the fact that which of these two approaches would you prefer or you see being preferred in the United States?
Yeah, you know, I think that as a federalist system with 50 different states, certainly the virtues of experimentation has often been accentuated, and that would go in many different types of scholarship and forms of scholarship in terms of critiquing the value of experimentation. And so that can certainly be seen in areas such as corporate law, where we don't have a single national area of the law. States are developing their own corporate law, Delaware being the predominant jurisdiction. But we certainly, and I think the two concepts are very related, because with experimentation does come flexibility.
Sure. Dr. Bajpai,
Yes.
I just due to the paucity of time and and as a matter of fact, I would also have to direct at the panel a few audience questions. If you could please sum up your views in about a minute and a half on this particular aspect, and then I'll quickly jump to the audience question.
Yes, sure.
Thank you so much.
As far as the theory of precedence is concerned, I feel that the course of scholarship is not changing. India is a country which is too dominated by the doctrine of precedent, especially in cases which are before the Supreme Court. They are expected to follow the theory of precedent. But the issue is that lately the cause of justice has emerged much more important than adherence to the doctrine of precedent. I would suggest that the ideas that the Supreme Court is recently exploring, they are not necessarily following the theory of precedents in many ways. Like, for instance, in death penalty jurisprudence in India, the courts itself has broken the tradition several times, going beyond the stare decisis or the theory of precedents in many ways. Like, for instance, very recently, the Supreme Court said that the potential to reform will continue to be a very important factor. However, many times there is a zigzag sort of course that the Supreme Court has adopted. So I'm seeing, so I would say only in conclusive remarks, that adherence to theory of precedents in the matters relating to the larger cause of justice is no longer relevant, because alternative scholarship has given rise to a different types of thinking. So now we are looking at the rights of vulnerable, rights of mighty, like in Sabrimala temple, the Supreme Court held that even the concerns of minuscule minority can be of importance to us. Their number is not important. Doesn't matter what the previous cases have been saying. So there is both ways. Sometimes the theory of precedence is held, sometimes it is not upheld. Both the things are happening. So I find that this flexibility is a very important pointer to the growth of the discourse on justice. So mechanical or instrumental sense of justice is not important. Substantive sense of justice is more important. Thank you.
Right. Thank you so much, Dr. Bajpai, and to the panelists for their insightful comments and views on this particular aspect. I would now like to quickly jump to the audience questions, and I'll see how much the time permits us to take them up. It's a very interesting yet intelligent question that has come up in the chat box, and that is, what are the factors that restrict the implementation of alternatives in reality? So who would like to take up that question? Dr. Bajpai, please go ahead.
I'll say, actually, there is a resistance to alternative scholarship in the mainstream academic community, because, as I have said in my previous remark, the alternative scholars are considered to be the others, and this othering effect is the first restriction. Secondly, there are pressure within the academic community, within the social community, to become more and more to adopt the role of that of conformist rather than deviant. Alternative scholars at times are considered to be one of the deviants in the academic community because they are talking about something else. So there are pressure. Third pressure is already where Donna has pointed out, that in terms of publication. So publications, though they mostly the publication community continue to be dominated by the classical scholarship holders. So they judge the alternative scholarship through the lenses of classical or dominant scholarship approaches. Therefore, the alternative scholarship faces a lot of hindrance in the process. And as I say that this mainstreaming of alternative is resisted because you are breaking the tradition. And moreover, in legal academia, there is a system of maintaining the status quo even for the scholarship. So we feel comfortable within our own way of thinking in our own domain of scholarship. The moment it is dismantled and challenged, there is a resistance. So probably these are some very crucial concerns which have some detrimental impact on the growth of alternative scholarship everywhere.
Thank you so much, Dr. Bajpai. I have a good 1 minute left. So if Professor Isabel and Professor Donna want to take 30 seconds each, I'm more than happy to come to you. Professor Isabel, I'll go to you first.
Thank you. I want to thank you again for the invitation. It was a pleasure to be here. And I just want to say that maybe next year we can talk about something that I think is also very interesting, which is the relationship between legal research or the legal academia and other disciplines. So how we as lawyers research with economists or with social scientists in issues that are much more complex. I'm thinking, for example, climate change. And what are the relationships that we have to establish and the methodologies that we have to use? I think that will be a pertaining question for the law in the next few decades. Thank you again.
Thank you so much, Professor Isabel. Point well taken. Dr. Donna, 30 seconds. Sorry for pushing you.
No, that's okay. So I too just want to conclude with a big thank you. It truly has been an honor, and I've enjoyed the opportunity to interchange. Funny enough, my concluding point was mirroring Isabel's. There was a time where legal scholarship, where the whole idea of alternative approaches involved sort of the law and movement, whether it was law and economics or law and philosophy or legal history. And so much has sort of grown out of that. And I think looking at some of the recent work in linguistics and law and linguistics and better understanding the ideas of artificial intelligence as well is, an area. So I think this is just the beginning of a very interesting and fruitful conversation that I look forward to participating in the future.
Thank you so much, Dr. Donna. With that, we would conclude this particular session. For all the viewers who've joined us from India and abroad, thank you so much.